And the final case we'll hear today is number 23P73, Brett Lyman versus Sasha Lancer. And it's going to be Mr. Cohen?
Yes.
All right.
Good afternoon, Your Honors. May it please the Court. I'm Jeremy Cohen, and I represent Brett Lyman. We're trying to recover possession of Brett's dog, Teddy. I'm here as an advocate for pet owners' rights. We are not here to advocate for a change in the legal status of pets. We're just trying to restore what the Superior Court found, which was that Brett, Mr. Lyman, is a co-owner with Ms. Lancer of the dog Teddy.
That doesn't seem to be disputed.
And
That Ms. Lancer has conceded that, I think, in her brief. The single justice recognized it. They're co-owners. So the question is, what are the rights between them?
Your Honor,
And how, if at all, can those rights be enforced at the preliminary injunction stage?
as we saw at the Superior Court, the finding that they planned that once, before, during, and after the relationship, if their relationship with each other ended, the relationship with Teddy would not. And even, in fact, for 6 months, they shared the dog Teddy. What happened here is that the single justice, she abused her discretion and made errors of law. First.
So can I ask you about that? Because you seem to suggest that the judge, not the single justice, but the Superior Court judge did not treat Teddy as a person. But if you look at the findings, it says they have an express intent to share custody. They acted on an agreed and shared custody, and they agreed to mutually agreeable locations for the exchange. I mean,
Understood,
when we talk
Your
about
Honor.
custody, normally we're talking about
Yes.
human beings, yes?
Normally.
Okay.
Do you
have any other example of any other custodial arrangement for real property?
Yes, for personal property.
Oh, I'm sorry, personal property.
I do
Yep,
for personal
sorry.
property. So citing to Westford versus Nobrega, 411 Mass 798, 1992 case, these were two co-owners of a lottery ticket. And one co-owner sort of absconded with it, just happened to hit the number, and the court said, no, you have to share the winnings. There's equitable relief there for the person. We have not, in any of our briefs, ever referred to a dog as a person. We do not believe that they have the rights of a child.
Acknowledged, but I think what might have been concerning to the single justice from the use of the term custody, which was in the Superior Court judge's findings, is the notion that this agreement between them to share ownership and to have a 50-50 split of time is going to involve a bit of supervision by the Superior Court, because it's not that simple. It's going to involve ongoing involvement in determining the little disputes that come up about where is the exchange going to take place, when is it going to take place. If one of the parties held to the dog for a little longer one weekend, then how is that made up, if at all? And so it begins to resemble what probate and family courts have to do in child custody cases.
Understood.
And so that was a long wind-up to my question, which is, can specific enforcement of an agreement, particularly an agreement this kind of vague, it just says 50-50 split, that's really all we know about it, can that be done at the preliminary injunction stage? Is that the kind of appropriate use for a specific enforcement remedy?
It is, Your Honor, for a few reasons. One is, we're doing this. All over the Commonwealth, these orders are in place, either from a preliminary injunction stage before this appeal, or at the end of a trial on the merits. There are shared custody agreements and being enforced around the Commonwealth
That's
where
not in the record, is it?
it is not in the record. But we would share that. We shared it with the Superior Court judge, where the enforcement, what these agreements actually provide, instead of needing enforcement, they provide a relief from the anxiety for pet owners who here are shown to both own the same piece of property, that when you don't have your dog, you don't have to worry anymore because the other person is supposed to deliver it up at a certain time and place, and the court is behind that.
Counsel, I'd like to ask a similar question to Justice Brennan, but I'm going to give you a very clear hypothetical.
Okay.
Two people jointly buy an antique car. There's a breakup of the parties, whatever the breakup may be. For the ownership of the car, do you have any case at all across the country where a judge can say, 1 week you have the antique car and another week you have the antique car because I find this to be such an unusual piece of property, I can't just give ownership to one party?
Well, we have cited to cases in the brief that all we're trying to do is dust off 200-year-old property law and have it apply to a modern-day property dispute, where sharing of ships and boats, going back to the 1800s, people could co-own or companies could co-own.
That wasn't sharing, as I read those cases. That was ordering a transfer, or in some cases enjoining a transfer, which is a one-time order. And it's a pretty clear black and white question whether the order has been complied with. Here, there's going to be ongoing supervision. The parties would be sharing the physical possession of Teddy Bear. How is that not going to drag the Superior Court into the same kinds of disputes that the probate court has jurisdiction of because the legislature said so? Here we don't have anything saying the Superior Court can do this.
Well, probate courts specifically won't entertain sharing agreements of dogs because they don't want to be overrun with these.
Right. But my point is they do this in the case of children for very important reasons pursuant to statutory authority.
Your Honor, I would ask...
Because the legislature wants probate courts to spend their time and the taxpayer resources on adjudicating those disputes in the best interest of the child. We don't have anything like that at the Superior Court level for dogs or cats or other pets.
We need it. And we need it because here are two people that have rights to the same property.
So can I say, I know we keep cutting off, but you say we need it, but you begin by saying you aren't here advocating for a change of the law. But why not? Why is it not time to have the law reflect current norms, which I suggest are that pets are not pure property?
And so, because we don't want to open the door to suddenly groups trying to say that pets have standing, that somehow they could bring actions on their own or through a guardian. The law that we go through here, especially Judge cites to Irwin, the single justice does, and so do we, because Irwin gives this court the permission to say, in Irwin, pets are special property, they are unique, and they have to be considered different. And in that case, they decide that's the first step to considering them as different type of property.
Is the answer to my question no? That you don't have a single case from across the country where a piece of property, real property, there's shared, I'm going to use the word custody. 1 week you have the car, 1 week you have the car, and we swap like that forever?
I do, Your Honor.
What is that?
Again, it's for personal property, and it's Houseman v. Dare, and we cite this case. It's a New Jersey case, 405 NJ Super 538.
It was a final decision in which the plaintiff, Ms. Houseman, I think, was awarded the permanent possession of the dog. I didn't see that as sharing and trading possession or custody or whatever you want to call it over time.
In my reading of it, I thought that after it came out of probate court and went to the higher court in New Jersey, it's the same fact pattern as we have here. And I believe that they recognized that they both had rights to share. Perhaps I'm not recognizing the holding for what it truly is. But the further issues here are the single justice said that a specific performance of something like this could never apply to could apply to real estate only, not to personal property. That's simply not the state of the law.
Well,
Clark v. Flynn says that you can.
Didn't quite say that. The single justice did allude to I don't see where the single justice said this could never be done as to personal property. If I'm missing something, or maybe you could point it out to us.
Well, I felt that under 231, Section 18, that she went beyond the scope of just looking at what the Superior Court judge had before her to issue the preliminary injunction. The single justice also went on to say you can't have specific performance for an oral agreement for personal property, which the case law, again, does not support. TFVBL, Summerby versus Bunton. So I felt that the single justice was going out of her way to find reasons not to apply this when the law is already giving us the permission to do it. Also, under 214, Section 3, the power of the Superior Court Justice specifically says to do all things regarding personal property and the division and ownership and distribution of that. And that's all that the Superior Court judge was doing.
Can you point to the specific words in 214.3.3 that go beyond ownership and division of the proceeds of sale to authorize ongoing sharing of possession? Because I didn't see that.
It doesn't say sharing, but it says to do all things related to personal property. It specifically
Well, it
says
doesn't
the
quite
recovery
say-
of chattel.
If we look at the words, to order a division or sale thereof, meaning personal property, make and order a proper distribution of the proceeds of a sale, and to do all other things relative to a determination of the ownership, division, and distribution of such property. I don't see where you're asking to determine ownership, division, or distribution. You're asking for possession to be shared.
Which I believe is division of the property, of the personal property.
Well, division would sound like something that Solomon would have ordered.
And we hear that.
No, neither party is asking for.
Your Honors, what are we supposed to do in this situation where the parties recognize they both own it, they both had the intention to share afterwards, and we get to this point where suddenly my client has no remedy at law because it's not been done before? It's time to do it. These pets are more than property. This is what's happening around the Commonwealth.
There might be a remedy at law if you could establish more on the merits what the content of the agreement was. It's certainly a concern that the court would be drawn into enforcing an agreement that just says 50-50.
And Your Honor,
And particularly at the preliminary injunction stage where all we have is the defendant's, your client's assertion that we had an agreement that if we split up, we'd share the dog 50-50.
well, notable in that is that the defendant did not supply an affidavit or anything to controvert our affidavit and our position. And regarding these agreements, which we shared with the Superior Court, they're pretty simple to write. It talks about the time, usually it's alternating weeks, and you can meet, generally it's at meeting at the police station, some neutral ground.
But we don't have such an agreement here.
Well, the
The
court could,
Superior Court judge would have to fill in a lot of details here.
there's a few details which but the fundamental thing is about the right to have an agreement. The agreements can be drafted based in part on what the parties want. Sometimes parties want just for 1 month and 1 month alternating. It can consider what they may have intended, which here, they intended this. They were intended.
If the parties had a specifically phrased and easily enforceable agreement that would not embroil a court in ongoing supervision of the disputes between the parties, that might be a different matter. Here, at least at the preliminary injunction stage, all we have is an agreement, if we credit the plaintiff's affidavit, that we agreed to split possession 50-50. All the details would need to be filled in either by the judge or by taking more evidence from the parties about what they intended or agreed to, and then the judge would have to find facts.
Or, excuse me, Your Honor, by counsel, by the parties, by the representatives of the parties themselves, which is what we do. You know, this.
Well, no one's saying that the parties can't come to an agreement and abide by it themselves, and if it becomes specific enough, then perhaps that could be enforced.
So what I'm hearing is if they had put this to a writing, the court would then enforce it because if it had the specificity, but because it was oral in nature, and the Superior Court judge did not give the specificities besides the general 50-50, that it's somehow not enforceable.
At least my point, and I'm not in a position to say today what the law is on this, but it's not the question of whether it's written or oral, but the specificity.
And I think that the specificity is something that's easy to overcome. It's practical, and that's how we are resolving these cases, sometimes in court and outside of court, with these shared visitation, custody agreements. We've tried to find a better word than custody, but we just don't have one right now. Because I just don't understand where it would now leave.
Maybe it's possible, but those aren't the facts in this particular case at this stage of the case. If an agreement is worked out between the parties, then there might be a different set of facts presented for enforcement.
Thank you.
Just let me make sure there are no further questions. Thank you. All right. Thank you, Mr. Cohen. We'll hear from Mr. Bongiorno.
May it please the panel, my name is Philip Bongiorno, law offices of Howard Cahalis. I won't belabor too many points here, but there's too many asks in the appellant's brief. First, they're asking you to find an implied contract, which still requires offer, acceptance, consideration, a meeting of the minds, and at least the material terms of a contract put together. That's not here. All that's here is a agreement that this pet is owned 50-50. There's no determination as to the sharing of it post-breakup, because I don't know of any couple that talks about what they're going to do when they break up.
Well, we have prenuptial agreements.
Well, if you're getting married,
It's not beyond the scope of possibility.
It is not.
That the plaintiff, having had a prior experience with this issue, says at the time they're acquiring the dog, if we should ever split up, I hope we don't, but if we do, my relationship and our relationship with the dog is important, so we'll share possession of the dog 50-50.
Certainly. And that affidavit is presented as evidence, but...
And it's not contradicted, so...
Yeah, it's not contradicted, but his own self-serving impressions of what they were going to do post-breakup do not make the terms of the contract here.
Well, they bought the dog, at least according to his affidavit, with that understanding, and then they started to perform that understanding. So let's just assume for purposes of argument that there is an agreement, a contract to share possession of the dog 50-50, if the parties themselves separate. Why isn't it enforceable?
They haven't executed any of the material terms. We don't know who's dropping off who the pet on what day, how long that pet is going to be with the party.
So how much detail, at what point, how do we discern at what point it's enough?
Well, I think
Why is that required? The day of the drop-off, the time of the drop-off, the location? Why is it, other than just we'll share the 50-50?
I apologize.
That's okay.
That's the essence of the custody agreement. That's the entire contract.
Let me give you a hypothetical, and it's actually kind of a real situation. So my mother has 3 sisters. They lost their mother when they were all in their 20s. There was one engagement ring that had value beyond the ring itself. It had sentimental value, and so they agreed between them, each of us gets it for 3 months out of the year. And they dutifully, for many, many years, handed it one to the other to the other. At one point, one of the sisters says, well, I'm just going to keep it. Do you think that the court has no equitable jurisdiction to enforce that agreement?
I think there is a series of facts that would...
No one ever said, well, you'll come to my house in such and such a town on such and such a date. It was just kind of, everybody gets it for a quarter of the year because there's 4 of us and there's only one ring.
There might be facts there that would suggest that there is more of a sharing in that situation, but I would also submit that that agreement very well was expected to last in excess of a year and would require a writing under the statute of frauds. We still don't have, there's no writing here. We have an affidavit from the appellant and a accumulation of text messages saying, yeah, you can see him this weekend, which are, in the appellee's opinion, no more than courtesies, and the residual of a post-relationship breakup.
My clause of the statute of frauds applies to agreements that by their terms cannot be performed in 1 year. I don't see where this agreement, at least on the record before us, cannot be performed in 1 year.
I believe the reasonable interpretation of both parties that this pet was going to live in excess of the year.
Perhaps we also hope so, but we don't know that.
Well, I might not survive tomorrow as well, but they still asked me to execute a contract for my mortgage, my car, and everything else. I would submit that this memorandum, or this custody agreement, would have had to be put in writing to be even remotely effective.
Let's assume it were in writing, signed by both parties. Is there some reason why specific performance would not be available at the preliminary injunction stage?
Well, if this was a contract in writing with all the material terms and offer and acceptance, then the Superior Court would have the authority to do a specific performance. But what the appellant is asking is that we find an implied contract with none of the prerequisites. Then he's asking the Superior Court to input the essential terms, which is what the Superior Court did. They said, sharing Sunday to Sunday, return at noon at a mutually agreeable place. That, in my opinion, is a material term of this type of contract. And then they're asking for specific performance of the contract that the Superior Court wrote.
Can I ask a question that at least I've been missing throughout both of these arguments? We are here to decide whether the single justice abused her discretion. The single justice didn't really get into much about the terms of the contract, etc. What her finding is that the lower court treated the dog as a child as opposed to personal property, and because of that, reversed the decision.
I find no error in the single justice opinion.
Don't you agree that the can real property be shared custody? What law prevents that from being done? Both of my colleagues just gave you potentially written contracts where that could be done. Real property could be shared as an agreement between two parties. So what did the Superior Court do regarding that? She found there was an agreement. She found that there was an agreement of shared custody. Maybe that's wrong. I'm not saying that that was right, but that's what she found. The single justice didn't really determine whether that was right or wrong. She just said the judge made a custodial decision. Tell me why that's not the case.
Well, I believe there was a previous single justice decision in Lou v. Swank where they determined that they were treating the pet here, which is personal property, as a child. And there's nothing in the legislature that allows the Superior Court to execute custodial arrangements for personal property.
But the lower court made a finding that there was a contract between the two parties that said there could be shared custody. Again, we're not here to determine, I don't think, whether that Superior Court judge necessarily made the right decision on that. We have to decide whether the single justice abused her discretion in finding that that was not what the Superior Court judge did, because that's not what the single justice said. She said she's treating this dog as a custodial piece of property.
I would submit that in the equitable remedies that what the Superior Court did is not something that it has the authority to do.
And that's where I want you to tell me where in the law or where in case, either statutory law or case law, that says a Superior Court judge in equity can't do that. Because that's what I think the gravamen of what the single justice did. She said a Superior Court judge cannot do that in equity. And I'll tell you, I'm having a hard time finding that a Superior Court judge can't do that, but I'm also finding any Superior Court judge does have equitable authority to do that. And if there's neither, I'm not so sure that's an abuse.
I believe it goes back to the issue of the contract, Your Honor. If there wasn't a material term in effect and the Superior Court supplied that term, so not only did it order custody, it ordered custody based upon its own writing of finishing the contract for the parties. I mean,
So I'm going to go back to what apparently might be a stupid hypothetical, but I'm going to use it anyway. Two parties buy an antique car. They split up. Ownership of the car is not a question. It was a jointly bought car. Can a judge in equity say, you get the antique car for 1 week, you get the antique car for another week, and you figure out how to get it from one place to another? What law or case law says that a judge in equity cannot do that? We might be making new law here, gentlemen, but you got to give us something that says either you can't or you can, because that's what it comes down to.
I would submit that based on Irwin determining the dog as personal property, that there's nothing here, there's no case law in the Commonwealth to indicate that this pet could not be shared. However, there's a wealth of opinions from courts all over the country that I've cited here that indicate that they're not going to get involved in the custodial sharing of personal property for the mere fact that it's a drain on judicial resources.
Are those cases about the terms of sharing or whether the pet should be shared versus awarded to one party or another along with other property in a divorce? Because as I looked at them, they didn't seem to involve enforcement of an agreement made between the parties.
I believe the cases cited represented both. One was where the court had ordered the sharing, and then due to the issues enforcing the sharing, dissolved the agreement. I believe that.
What case was that?
I think that was out of Florida, Your Honor.
So then, if I don't want to interrupt you if you're still looking.
No, go ahead.
So then, if I can, to Justice D'Angelo's question, because I'm not sure I heard the answer. If there's no Massachusetts law on this issue, how can it be an abuse of discretion for the judge in the Superior Court to make a decision that seems to fill the void? I mean, it may be ultimately wrong, or it may be right, but isn't that what discretion's all about? And we have to figure that out down the road.
Certainly, but the trial court is also bound by the precedents of the Commonwealth, and we don't.
And what precedent, again? I thought we just established that there was no precedent directly on point on this particular issue.
Well, again,
I'm wrong.
it's Irwin. Irwin describes it as unusual property, the pet in question, but it does not remove it from the personal property category and remove it to what the plaintiffs are referring to as an equitable sharing agreement.
And is it your position that simply by using the word custody, that the Superior Court judge then, by definition, was treating the pet as a child? Or could there be different interpretations, like custody of a really, really terrific antique car?
I can't speak to what the Superior Court justice's mindset was, but the term custody would imply more than a personal property, which I believe the prior justice had equated a dog to table and chairs, unfortunately. And I think that was Justice Lemire's decision in Lou v. Swank.
But do you see a reason why an agreement to share an antique car between two owners couldn't be specifically enforced?
If there was actually an agreement, no, I don't see why that couldn't be enforced. But here we don't have the terms of the real terms of an agreement to share.
But that's not before us, is it? We're looking solely at what the single justice did as to whether she abused her discretion. It was the trial court judge that made the finding there was a contract here. And that's ultimately what you guys maybe will fight out in the Superior Court. But the single justice of our court said that that's not what the trial judge did. She treated this dog as a person in custody, and therefore she found that that was not valid.
Well, she found that there wasn't going to be a likelihood of success on the merits initially.
Do you see any distinction between enforcing this agreement for a 50-50 sharing? Do you see a distinction between doing it as a preliminary injunction versus after a trial?
I want to briefly push back on the term. I don't know that the parties agreed to 50-50 sharing.
All right.
They agreed-
Understanding that there are facts to be developed, but on the record before us, all we have is the plaintiff's assertion that there was.
Mm-hmm.
Do you think that's any less enforceable at the preliminary injunction stage than after trial, if that was the agreement that was found to have been concluded between the parties?
Again, there's nothing here that forms any basis of a contract, and I don't believe at the preliminary level that there was the authority to issue any of that. After trial and the judge taking into account the credibility of both parties, there might be a different situation.
So, and I know we're over time, but so your position then is sometimes, as you well know, in the Superior Court right now in a civil case, it could be 4 years down the road before you get a trial. And so you're saying that the judge doesn't have authority equitably to go and say, that's just not fair, that's not right. So 4 years from now, when we finally get this case to trial and resolve it, then, you know, the dog could be here, dog could not be here. It's 4 years later, there's attachments that are formed or lost. Why can't,
I mean, I can't
just not following
comment on the
Okay.
docket for the.
I'm just talking about the injunction versus waiting for the trial, that a judge doesn't have some authority to say, well, this is why an injunction is appropriate in this particular case.
If there had been more concrete terms and more to rely on, I would perhaps agree. But here, we're talking about, she essentially wrote the contract for her, and I don't believe the single justice erred when she overruled the Superior Court.
Thanks.
All right. Thank you very much to both parties for your arguments. That concludes our sitting for today.